a video more to the point than the last one that I made about this, because I went off onto more modern political issues. So, Charter of the Confirmation, 1297. So this confirms the Great Charter and the Charter of the Forests and itself, right? So this is actually, you can go onto the government legislation website of active live modern laws, and this is there. It's live, right? Now, what's important to us is that it actually sets out the word same is important. It says that the Great Charter of Liberties and the Charter of the Forest. So we've got the Great Charter of Liberties, which is the 1100 Great Charter of Liberties, and the Charter of the Forest, which were made by common consent of the realm in the time of King Henry, our father, shall be kept in every point without breach. Well, that is actually the law that I used for the Stonehenge Tunnel when I put my legal complaint into judicial conduct about the fact that it goes against the Great Charter. And the Magna Carta retains the Charter of Liberties, as does this. The Magna Carta itself retains the Charter of Liberties, and this confirmation of the Charters retains it as well. So I was right about that. So that means that all the laws of Edward the Confessor, all of the Edward Confessor laws, are actually kept, undoubtedly, not only in the 1215 Magna Carta itself, but actually this. Now, the 1215 Magna Carta retains the Charter of Liberties and Edward the Confessor in it. And this itself, this one, 1297, when this is the 1297, this confirmation of liberties is put into law at the same time the Magna Carta is actually put into official legislation. It's up on the website, right? Although they're claiming there's only 4 clauses left. Now, this says that the Charter of Liberties cannot be changed or adapted or modified. Now, the Magna Carta has been repealed except 4 clauses, which Elizabeth II did quite a lot of it in the 1967 Criminal Law Act, as well as modifying the Tumultuous Petitioning Act as well. But they still continued to open Parliament with all the ancient rights and privileges. Now, all of the ancient rights and privileges includes all of them in Magna Carta, right? Now, the interesting thing about that is that the Charter of Liberties says that all the peers and barons have to stand for their crimes. Now, what the Magna Carta does is it invents privilege, more or less. It actually invents the privilege that the barons and lords have the privilege of only being held to trial or fined by their equals, right? So they can only be, they have to stand for their crimes, but they're judged by their own, by the House of Lords, effectively, right? Or their own barons. So they themselves are their own kind of group of judges. The common people have the right we have our peers, our peers judging us, but we can actually appeal. If we don't agree with that judgment, we can appeal up to those peers who usually have their own judgment of themselves reserved, right? The Charter of Liberties says that they have to stand for their crimes. Now, what the Magna Carta does, to put it simply, is it doesn't prevent them from being prosecuted, because if the Magna Carta did prevent them from being prosecuted, then it would be against the Charter of Liberties, right? So what it does is it puts a cap on it, and it says that, well, they can only be prosecuted by their equals, right? We've got the right to be judged by the barons, if we're not satisfied and content with the judgment of our own equals under common law. We can appeal to the barons and lords, but the barons and lords have the privilege of being judged by their equals. Now, this must not have been considered to be in breach of the Charter of Liberties, because nothing was repealed from the Charter of Liberties. It didn't prevent its function. What it did is say, okay, yes, barons and lords shall stand for their crimes, as in the Charter of Liberties, but they shall be judged for those, fined by their equal peers, not by the common people. So we can get them prosecuted, right, for crimes, in their own jurisdiction of courts, right? Okay, so it's kind of putting a little bit of a restriction on it, that we cannot have them tried, but they will stand for their crimes. So, you might argue it's restricting the Charter of Liberties, but it doesn't stop the Charter of Liberties principle from saying that they will stand for their crimes. Okay? Now, the Magna Carta has got the fact that, it can be judged by our peers by a fair trial, but also that you can pursue your cause for judgment by peers. And this is where the principle of, in the William Penn trial, and in some of the old petitions, Lex Talionis, in some of the 1620s petitions, they say that you can be protected to follow your cause, which is the same as hue and cry, which is the same as the function of the police. But you can also have a cause to the Parliament which you're pursuing, right? Not local crimes. It's policing policies of government, right? But you've also got civil cases as well. Now, what they did in 1661 is, similarly to the barons and lords, they shall stand for their crimes, right? But they put a sort of cap on it, so they partitioned it. That thinking of it now, I haven't really seen it this way, but it's almost like the House of Commons and the House of Lords, right? So can you see the House of Commons? They've got it split into two. They've got the House of Commons and they've got the House of Lords, right? Why even have a House of Commons and why even have a House of Lords? You've got the two houses. We've got the right to petition the House of Lords, and everything that goes through the Commons then goes through the Lords. In a normal case, if you're satisfied with the outcome of common law, right, then that's it. But if you want to appeal higher, you have the right to appeal higher. This is the whole point, right? So it's basically the Magna Carta, really, with that everyone should stand for their crimes. It's really superimposing the model of the House of Commons and the House of Lords. That's what it's kind of superimposing, suggestive of. Now, in 1661. We've got this principle under the Magna Carta of pursuing your cause. Now, it doesn't necessarily have to be a crime or a civil grievance or a matter of church, state, and law, right? It's still, you're pursuing a cause through the judicial system, of which Parliament is part of the judicial system, because we've just said you've got the Parliament, the Lords, right? Usually you start with the common law and then you appeal all the way upwards if you want to appeal, right? But you can go straight to the Parliament when it's a matter of church-state law from the start, okay? You can start with straight away with a complaint to the Parliament or a case to the Parliament or King over how the country is being run. You want the country is running to be changed or altered, or the people want it to be altered, right? Or the religion or church or whatever, right? Or anything that the government are currently doing that you wish to have, the law changed on it or a law made or whatever. This is the point, right? Now, everyone is protected to follow their cause if they show just cause and go through the proper procedures, right? Just like with a criminal prosecution. And we've got law and legislation for that. But that's mainly in their local jurisdictions under certain particular courts or a police commission jurisdiction or a civil court jurisdiction, the circuits, right? When you go to Parliament, it's straight to Parliament. Now, we have got now this thing where you can only, you appeal to the Supreme Court instead of the House of Lords. But that actually is not absolutely set in stone, because you do have the right of free subject to petition the House of Commons through the Bill of Rights. You've got the free subject, and that is evident through, it's evident through the John Beswick and Henry Burton cases and John Pym in Parliament, petitions for release of prisoners and so forth, like seeking pardon, basically. But you aren't always appealing something. You might just be bringing a case, right? But the matter might not be in a local court can't get the tax changed on tampons, right? They just don't do it. A local court doesn't make and change laws. You aren't bringing a cause to a local court, right? You're bringing a cause to the House of Commons or Lords or to the King, right? Now, everyone has got that right to be protected to follow their cause when it is a just cause officially, right? Like the police. But they had a certain number of persons, right? That they, in 1661, they said, if you're having over 20 people, then you've got to get permission from a local jurisdiction to be able to Parliament in order for you to have your privileges. Otherwise, you can't do it, and you will be punished because you haven't put it on record properly or officially got consent. You can get consent if it's under a certain amount of people. In a way, they can't stop you from doing it because it's in the Magna Carta, just like they can't stop lords and barons for being tried for their crimes, right? But they're only tried by their peers. Now, we're tried by our peers, except when we're pursuing a just cause, particularly to Parliament, because we're actually seeking judgment from the House of Commons, the House of Lords, right? So it's similarly, the 1661 Tumultuous Petitioning Act didn't prevent the Magna Carta rights, but it kind of made a little bit of a, you've got to get consent or permission, right? That's a little bit like, in a way, it's kind of sort of a similar notion to the fact that, lords and barons can be prosecuted by their equals. They can be prosecuted and should stand for their crimes, but only by their equals, right? Now, with the 1688 Bill of Rights, said that anyone who is petitioning is protected, right? They can't be imprisoned or prosecuted. And it's our right, we have a right to do it, okay? But you have to be doing it, It says all prosecutions are illegal, all of them. Now, for Article 9, for illegal prosecutions by the King's Bench for matters cognisable, decidable only by Parliament, that is petitions to the Parliament or any work by the Parliament, by elected members of Parliament, elected cabinet members, or the House of Lords. Illegal prosecutions by the King's Bench for matters cognisable, decidable, debatable only by Parliament. Well, prosecution is prosecution, right? So that is kind of reiterating the Magna Carta that barons and lords can only be judged by their equals, because that means that they're reserved for judgment in Parliament. That means that the matters of the barons and the lords and their work for Parliament is punishable only in Parliament or by their equals. But then you might say, well, what about barons and lords if they're not actually doing any work for Parliament? Like Lord Hanningfield was in front of the Southwark Crown Court. Lord Hanningfield was in the Suffolk Crown Court, and they were saying, the CPS said that he wasn't work for Parliament. Now, firstly, Sir Thomas Erskine May claims in his book that fraud or forgery is a breach of privilege. Now, that would be the same as saying if you were claiming that you had petitioning protection when you weren't doing a petition, right? Like in William Penn, when the jury said that they weren't doing any petitioning. The jury in William Penn said they were just stood in the street talking to people and they weren't doing a petition, right? So they wouldn't have been covered by any privileges because the jury said that they weren't doing it, right? Now, so, that's, if you claim you're doing it when you're not, that's fraud or forgery. So you haven't got the privilege because you're not even using it anyway, right? If you are, you are, right? But with Hanningfield, if he's lying about his accounts or lying about his, dealings, he's kind of forfeiting his privileges, really, right? According to Sir Thomas Erskine May. But because Magna Carta says that barons and lords can only be judged by their equals, it doesn't matter whether he's doing work for Parliament or not, right? Or whether he was committing fraud or forgery for a breach of privilege. Because according to Magna Carta, no matter what Hanningfield was doing, whether he was or was not working for Parliament, or whether he was or was not committing fraud, right? He has got the privilege for being Lord Hanningfield of only being judged by his fellow members, which now would probably be the Supreme Court, right? Or Privy Council, or Lady Chief Justice, or I don't really know if there anyone in the High Court who qualifies as being equal to him, any of the justices working in the High Court. I don't know, but some, I don't know whether it qualifies for knights. I don't know about knights, the Archbishop of Canterbury, but whatever. But they've said they're doing it in the Supreme Court now anyway, right, since that Constitutional Reform Act 2005, right? So, if you're a member of the House of Lords, if you are Lord or Baron, right, you don't need to have a cause. You don't need a cause. You just need to have a title to be privileged, right? So when it comes to Article 9, illegal prosecutions by the King's Bench for matters cognisable, decidable, debatable, and by Parliament, right? Well, you won't be a member, if you're a member of the House of Lords, right? It doesn't matter, okay? Article 9 of the 1688 Bill of Rights only really applies to, you only really need anything other than the Magna Carta for cabinet members, members of Parliament, or anyone who is petitioning Parliament. Or you can also have their servants, people are working for them. But how far that extends through government and when they're doing their work or not, it doesn't extend far through government if they are committing fraud or forgery, because that is a breach of privilege, right? And they're not barons or lords, right? So anyone who is not doing what they say they're doing, right, apparently has not got the privilege. So Article 9, I don't think Jeremy Johnson KC in his Lord Hanningfield paper was correct at all. I think that the paper is mainly jargon, and that's a fact. I mean, his paper in its entirety is wrong. But, he wasn't going to challenge the Magna Carta being repealed. Now, can Magna Carta be repealed? Right, because first we need to establish the Lords and Barons' privileges first before we go on to everyone else's, because illegal prosecutions by the King's Bench for matters decidable, cognisable, debatable only in Parliament are causes that we brought to Parliament to be decided, and obviously you have to bring it. Someone has to bring it to Parliament, right? Now here it says that the Charter of Liberties and the Charter of the Forests shall be kept in their entireties, right? On every point without breach. And, now this is important now, because we're going on to singular words, right? So this is not all, this is also in addition to that, and also with that. So with that, and in addition to what we've just said, it says that, and we will that these same charters. Now that is critically important, because that means these same charters. So that is the one that we've got, the confirmation of the Great Charter and the Charter of the Forest. So these same charters, so the confirmation of the Great Charter, 1297. The 1297 confirmation of the Great Charter, right? Which is this itself, which is saying that those ones shall be confirmed and not changed. So this, the same. These, the same. What it's saying is also this itself, the actual thing that you are reading off, surely, to say that those charters shall not be changed, and they shall be recognised and upheld, right, on every point. And this, which is telling you that, this thing itself that is telling you that. But it says these the same, not this the same, these the same. Now, the 1297 confirmation of the Great Charter is put into law at the exact same time as the 1297 Magna Carta. The Magna Carta, which is not the Charter of Liberties, but the Magna Carta itself retains the Charter of Liberties and Forest, right? That's what the Magna Carta does in its opening part. It retains the Charter of Liberties and the Forest, okay? Right? That's the whole point of it, right? And so that is 1297. They actually confirm it, right? And here, with this 1297 confirmation of the Charter, you don't do a 1297 confirmation of the charters, which you do it at the same time you put the Magna Carta into official law, and then say in it, when the Magna Carta says that the Charter of Liberties and the Charter of the Forest shall be preserved in their entirety and upheld, exactly, right? You don't do that, 1297, with the confirmation of the Great Charter, when the same time, 1297, when you put the Magna Carta officially into law, and say these the same, right? Because that's what the Magna Carta does. It preserves the Charter of Liberties and the Charter of the Forest. The same as this confirmation, which we're reading off, says that it here will preserve the Charter of Liberties, 1100, and the Charter of the Forests. The same. Because he's doing the same as the Magna Carta. Now, some people call the Magna Carta the Great Charter, but the Great Charter is meant to be the Charter of Liberties, right? But they've got the words here, that the Great Charter of Liberties. But here it says confirmation of the Great Charter, right? So, that these the same. Well, I would have thought, and this is probably going to be the critical legal argument for the courts, which is when it says, and these the same, right, does it mean the confirmation itself? The 1297 confirmation, the thing that you're reading it from. If you're reading a piece of paper which says that in absolutely no circumstances whatsoever shall the Charter of Liberties and the Forest be repealed or reduced or modified in any way, and it shall be upheld, and this the same, then surely it means a sheet of paper which is enacting that you're reading it off. So surely that has to be the confirmation of the charters. And I noticed that some of the confirmation of the charters has actually been changed and repealed by the looks of it. So that would be a breach of it. But I know that the Magna Carta, there are 4 clauses on the government website in force. One is the Ancient Liberties of London, which I think Sadiq Khan is in breach of, putting up tolls, toll charges on roads, charging people for using the roads, right, and additional and extra charges on roads, right? Does it mean the Magna Carta as well? I think when it says these the same, I think that it means the main charters. The main charters that are the same or similar. That's what I think. And then I think that through that basis, when you're looking at these group of charters, right? Because this thing here is only a piece of paper to say that the other two pieces of papers are to be always valid, never changed or challenged, and always put to effect, right? And it says this the same, right? So is it also including Magna Carta in there? Now, if Queen Elizabeth repealed some of Magna Carta in 1967, which some of those clauses were the privileges of the peers, they're still opening Parliament every time Parliament opens, and the Speaker's putting a petition to invoke all of the ancient rights and privileges ever made to effect, right? That's his petition to the Lord Chancellor. They cannot possibly be doing that to effect if they've been repealed. So the privileges of the barons and lords, right, can't be repealed because they're lying when they open Parliament. The Speaker of Parliament is in contempt of Parliament, right? Now, he might have the right to petition, right? He might be asking for it, might be petitioning for them to be able to come into effect, but are they approving it? Well, I don't think they're rejecting his petition. I don't think they're rejecting it and saying, no, we won't have them all to effect, or else how can they, isn't it the fact that, of course you can, we'll vote them to effect and we'll proceed with the Parliament. If they're not invoking them all into effect, it seems to me like they're invoking, he's saying all of them or not. If they reject the petition, which is asking for them all into effect, then they haven't got any of them, surely, right? But all the majority of these things are in these documents that will under question scrutiny now. I do not think that it's possible for Queen Elizabeth to repeal that the Barons' privileges from the Magna Carta if this document here is these the same, right? Which is also this itself we're reading off and the Magna Carta. And the thing about the 1688 Bill of Rights, which is way after this, right? It's like, 400 years after this, is that the 1688 Bill of Rights, it's not just brand new in the sense of it's not radical new law. It's yet another need to confirm. It's another need to clarify. It's another need to reestablish or ratify or, in fact, recognise the rights. And we've got the evidence for that is in the 1670 William Penn trial, full record, and in petitions, in the actual petitions, which a lot of them got burned in the Fire of Parliament, right? A lot of them got burned in the Fire of Parliament in 1834. So we've got Edward Vaudrey's petition from National Archives, which says that to follow his cause, be protected to follow his cause to prove his case to the Parliament, and if he's wrong, then so be it, he be punished, whatever, as to be adjudged with his cause. If not just, if his cause is not just, or if he, if he doesn't have a cause, well, surely, in 1688, they're actually making it legislation that you won't be prosecuted for following a just cause, a petition, that's for sure. And the 1689 Claim of Right says that you cannot be put in prison. Okay? There is an argument about if you look at the Article 9 of the Bill of Rights, what about illegal prosecutions? illegal prosecutions are through the courts for matters that you are for the which matters of church, state, or law which are decidable by the Parliament, right? Does that mean that clause, illegal prosecutions by the King's Bench for matters of decidable, debatable, and by Parliament, does that mean that the right to petitions clause is on that basis and terms, right? That illegal prosecutions through the courts for matters that are decided by Parliament, right? Or does it mean ultimately and independently, separately, you won't be prosecuted for following just cause, right? Is that what it means to the House of Parliament or the King, right? Because that would mean that Parliament is its own judge of its own matters. That's for sure. Parliament's its own judge of its own matters, and that definitely goes for MPs. But the thing is, you are bringing matters to Parliament. You are bringing matters to Parliament when you're petitioning Parliament, okay? Now, that is different for the House of Lords. The case with Hanningfield is a red herring because Jeremy Johnson KC did not challenge the Magna Carta repeal. He wasn't there to do that. What he was there is to say that all Hanningfield's matters and affairs are the business of Parliament, all of them, right? But they're none of the businesses of the courts, the Crown Court, with a jury, anyway, right? Because he's Lord Hanningfield. Now, the thing is, if you commit fraud or forgery, according to Sir Thomas Erskine May, it's a breach of privilege because you're not doing what you say you're doing, right? That's like William Penn and William Mead. Are they doing what they say they're doing? Were they petitioning in the street or were they just talking to people in the street, right? Are you doing what you say you're doing, right? So, with Hanningfield, the thing is, right, it doesn't matter if he's doing what he says he's doing or not, because he can't be tried in the Crown Court. If he's committing fraud or forgery, then he doesn't get Article 9 of the Bill of Rights, which matters illegal prosecutions by the King's Bench for matters decidable, cognisable, and by Parliament, because if he's committing fraud, right, then surely he's in breach of that privilege. But the Parliament are the judge of that anyway. It says that for their matters, right? But what Jeremy Johnson KC was doing, he was saying it was about, are we touching on matters of Parliament or not? There is absolutely no question, dispute, or debate whatsoever. It's not a matter of whether you're touching on matters of Parliament or not when you've got the Lord Hanningfield there, right? He is the Lord Hanningfield, right? It doesn't matter if you touch his, if you touch his testicles. You can touch on what you want. He is the Lord Hanningfield, right? So Magna Carta gives him the privilege of being judged by his peers. He wouldn't be being judged by his peers if he hadn't broke the freaking law, right? If he hadn't broke the law, if he hadn't committed a crime, fraud, forgery, or whatever, murder, theft, right, he wouldn't be being tried by his peers, would he? Because he wouldn't have done anything wrong. So why would he be being tried at all if he hadn't done something wrong or illegal? He wouldn't. So when he does do something wrong, then he's tried by other members of the House of Lords. And if you want to say it's Three Stooges in the Supreme Court, then you can have whatever you want. Miss Cobweb, I don't care, right? It's that group of people. For us, it's different because we have to be we have to show just cause and actually have one. And if you're committing fraud or forgery, then you don't, or you're not even doing it lawfully. But there's a question that even if you do commit fraud or forgery, then you still are going to be, it's matters that you're putting to the Parliament. So you've got the privilege of having them. You've got the matters of you've got the privilege of having Parliament to decide if you did commit fraud or forgery, right, in your petition. So that's Article 9 of the 1688 Bill of Rights. Doesn't really matter whether you're a baron or lord or not, right? And if you're an MP, you're usually always engaged in matters of Parliament, unless you're going out to the pub on a Friday night and headbutt someone, right? Which is different. So now, with the right to petition, that is the right of the subject to petition the king, and all prosecutions against you are illegal. That is under the presumption that you are doing what you say you're doing honestly and justly, right? And it doesn't matter if you fail to prove the case. If you fail to prove to the government that the tampon tax should be changed, and they don't change it, you still were following your just cause honestly and truthfully and lawfully, right? That's the basis of it. So if you're not doing what you say you're doing, right, I still think that you still aren't. I don't think you got prosecuted in the normal courts, because it is Article 9 as well. You got the privilege of being judged by Parliament if you have committed fraud or forgery, which is it. The basis that they were using for Lord Hanningfield in Jeremy Johnson's paper really is the basis that they should have had for us. And that is that it touched upon matters of that's to Parliament. And it doesn't matter whether you actually did something wrong or fraudulent or whatever in those matters. That just means you can actually be tried by Parliament, as opposed to if you did it honestly and you didn't commit fraud or forgery, even if you don't successfully prove your case, like a prosecutor wins or loses, you're wavering. I think what Thomas Erskine May is getting at is that you're wavering your protection, and you can be prosecuted by the Parliament, or the Supreme Court or whatever, if you're not doing what you say you're doing. Honestly, that surely has to be the logic behind it. And as for Hanningfield, I think Johnson was completely wrong, but Johnson was not there to disprove Queen Elizabeth's subsequent mistakes and repeals and other errors in government, or else I don't think he would have been promoted through the ranks to Judge Jeremy Johnson KC. He's there to continue the charade and the game and the errors, and continue the corruption. Unfortunately, he's not there to resolve it. Fortunately, someone was there in 1688 to update the, to reaffirm and confirm the laws and rights, fortunately. So, that's effectively it. So I think that it does mean the Charter of Liberties as well. And this piece, this law that we're reading it off, obviously itself, and the Charter's the same, which includes the Magna Carta. Now, I don't know whether you could say that does this also therefore mean that the 1688 Bill of Rights has to be adhered to and followed, and if not, any order or judgment is null and void? Well, it all depends on if you believe that the 1688 Bill of Rights right to petition in the 1688 Bill is the Magna Carta law. The Edward forgery, to be protected to follow your cause. If it is hue and cry, if it is the right of the people to pursue just cause, whether criminal, civil, or of church, state, or law, right? And therefore be judged either by the jury, if local, or if in Parliament by the Parliament, or the King. So that's it, really, and you don't really, I don't think, but you're protected to follow the cause, right? So that means to prove it, so you might say, what does that extend to? Well, the current argument and the current problems we've got is over, are people going too far and doing things that are not really in pursuit of a just cause, like Extinction Rebellion and Just Stop Oil. Now, the thing is that you can be liable under the 1689 claim of right for civil damages, for civil matters. So if you're going about these protected, you're only protected from the public interest, the public, you're protected from the public, the common law. You're protected from, being prosecuted for criminal matters. But that's what it suggests in the 1688 Bill of Rights and the 1689 Claim of Right. It suggests that you're protected from being criminally liable for pursuing a just cause, but not for if there is any damage or so forth, right? It's just not a crime. You see, this is the thing with the fire. I don't know about the fire brigade. That they're definitely not prosecuted criminally if they spray everywhere with foam, but can you make a civil claim against them? Usually, how it's done now is that you're insured for things like that. This is the thing, that they're forcing you to have car insurance. They're saying you're not allowed to have a car unless you have insurance. Houses are insured. Property is insured. What is the point in having insurance? Now, no one necessarily, it's not an insurance job, as long as it's not a strategic criminal insurance job where, the bank burns itself down, or, it's like an insurance job. Someone goes and, destroys their own things and claims off it when, whatever, they might not be worth that much. That's a crime, an insurance job. But if it's just, the wind blowing around, or this is the thing, Brad blowing a gale, if a load of protesters kick off unexpectedly or whatever, and they happen to target a certain place for a just cause which arose out of their own consciences, not colluded with the bank, then, and the building suffers damage, they're not criminally prosecuted. The building will be covered by insurance, and it will be insured, and it will get repaired. And, it wasn't an insurance job, a crime from the owner. So, should the protesters pay for all the damage if it's already insured? Or maybe should they pay the deposit bond or whatever has to be paid or whatever? I don't know. Things like this are not even being argued in the courts at the moment. They should be being. They're not wanting to entertain the true fact of things that need to be being entertained. This is what they should be in court doing. Because also, on many occasions, local councils go into a court, and if there's damage, they're saying, "Oh, there's £10,000 worth of damage," and they're actually committing a fraud. They're committing a fraudulent claim, and no one's challenging them. There's no prosecutor. There's no one's saying, well, no, it's not this amount of damage. If you're in a civil court and a civil claim, the thing with the Crown Prosecution Service is that, the council sends them a load of numbers, receipts, money, and says, it's 10 grand. And then the Crown Prosecutor goes in there and says, oh, this person is prosecuted for criminal damage. They caused £11,000 worth of damage. It's only beyond reasonable doubt. No one really scrutinises it. I don't think the jury scrutinise that. I don't think the judge does. I think the prosecutor goes in, he goes, the council say there's £10,000 worth of damage. They've sent a piece of paper in. They're not going to send a police officer investigating that to go through the council books to check it. They prove it. They manage to prove it beyond reasonable doubt to a jury because the prosecutor rolls it up and says it, and the judge goes, very well, then whatever. No one challenges it. Challenge the jury. Challenge a juror. Stand down. Challenge the juror. Do you want to, you're a solicitor, I'm advising you to plead guilty, not guilty. You're being challenged. Challenge the council, right? Most people are too busy defending themselves and trying to keep themselves out of prison, shitting their pants, or kicking off about the environment like Roger Hallam and causing a commotion in court about, how the environment's been damaged, than really actually, paying attention to the ball under the cup, right? If Gail Bradbrook from Extinction Rebellion doesn't end up being prosecuted criminally in a court as a criminal and being forced to plead to a crime, if instead she ends up in a court, a civil court, and the bank say, you smashed our windows, right? It's £20,000, or even £100,000, or look at those Just Up Oil people on the roof of the defence building, and apparently they caused £500,000 worth of damage, right? Well, the case is going to be about the damage and how much it is, right? There's this amount of damage and you caused it and you owe us this money, right? At that time, suddenly the most important, because they're not being prosecuted criminally for an offence, the main thing is, how much is this actual damage, right? Is it really that much? And then suddenly you would have people like Gail Bradbrook with her entire arsenal of, suffragette women, hundreds of Extinction Rebellion women would then suddenly be interested in, is that really £500,000 worth of damage? How much do those widgets really cost? And, is that really broken or not? And then it might actually not be, who's actually doing the work on it. This company seems very expensive. They're putting, it's like the local council, it's meant to be non-profit, but now the highways, we'll change all the grates, so they don't need changing, or we'll just put a cycle lane in, we don't need a cycle lane. Who's been contracted out to do it? Or my friend, John Simpkins, what's he on? £100 an hour. Well, £100 an hour? Maybe can you get a company in to do it who's cheaper than that? So there's a lot of, costs that aren't really true. And that's what these people aren't being challenged on. But also with the council in Manchester, when I got done, removing a couple of stickers from speed cameras that fade off to blank anyway. And there was only about 3 of them in one place. In one county anyway, it was all tosh, but when you're trying to protect yourself under life and limb in shitting your pants of a criminal charge, that's the last thing that you can. They've literally, they've got you in a corner terrified, so they're poking you with multiple sticks which aren't even true. This is like the illegal road signs, but yeah, they're not up in front of the court with their illegal road signs everywhere. Why aren't the police in the court for entrapment around the whole of England? Contempt of court all around England. This is a problem because they're big bullies and they've got lots of money, radios, personnel, helicopters, a full-fledged force against you. And when a force acts against you illegally, against the law of the land, you can protect yourself, arm yourself to defend yourself against them, which is what they're doing with the ULEZ cameras. They're being extorted with fines and their vehicles forced off them when it's against the ancient liberties of London in Magna Carta, which is in force on the government website. And they've got a legal right to protect themselves against those fines and their fellow citizens and disable those cameras. And they don't even need to be petitioning. They don't actually even need to be petitioning because immediately those tolls in London are illegal. Additional charge within London is illegal. You don't even need a petition to Parliament. They are breaking the Magna Carta in law, and all those charges are void and null from Sadiq Khan. That is it. And you can protect and defend yourselves against them. They're null and void. It doesn't even need to be a petition, The Stop ULEZ petitions that they are doing to officially get the whole thing stopped, they're also protected for that as well, and it can't cause harassment. In fact, Sadiq Khan is the one who's harassing half of London. Sadiq Khan is put an illegal, unlawful, void order through government, and he is terrorising and distressing, stealing from citizens. And I don't think it can ever... someone sent him a bullet in the post, and I don't even know where that came from, but, someone tried to shoot Donald Trump the other month. Khan is such of a scapegoat that if it's, they can't. It's worse than Julian Assange. You know, can literally would. They used to hang people. We don't have hanging as a punishment anymore. What the public can is himself placing himself in very serious mortal danger, because what he's doing is treasonous, corrupt, and in contempt of the City of London. And if that can never be ever declared as the truth in the newspapers or press, and if he never faces a prosecution, then that is an abomination of the Constitution of England, right? He used to be a lawyer. He should never have been allowed to be the mayor. He's in breach of his privilege. That is a fraud and a breach of privilege. What he's done, and the order is void. And he's got his Transport for London, all these Team Legal. It's all corrupt, and no wonder you've got all these people taking the cameras down and having confidence to do that, and loads of people refusing to pay the fines. They're not just going along with it happily. They were never meant to. The whole thing is so beyond the law that no one would ever believe that it was legitimate. The amounts of fines and doubles and triples on the fines are so insanely ludicrous. And then he's wanting to put a charge on the Blackwall Tunnel. Khan is an absolute maniac, and he needs to be face justice. And Judge Swift also, in that civil case, Judge Swift is in contempt of court for that. The charters, anything against the charters are null and void. What is against the charters? Having additional tolls and charges for use of roads in London when the money is meant to be collected from the people. It's a free way. The main tenancy on the road has been paid, right? And all of these cases, all of the Stop ULEZ cases are a just cause, and they do have petitions to Parliament, and they have got privileges. All of the cases, even Joseph Nichols calling up Simmons and giving them abuse. He can give whatever language he wants in the face of extortion, of actual money's been taken out of people, and false orders of bailiffs coming around to take things from people. Right? That's criminal. So, even without the petitions, in this case of, Alison Young and Martin Whitehead, Kevin Strader, Nick Arlott, Lloyd Dunsford, and all the other cases, Kingsley Hamilton, the rest of them, it's all one cause. And this is what this thing here says, that it has to be recognised. Because it's all the Magna Carta the same, right? And the 1688 Bill of Rights clauses, which are reaffirmations of the Magna Carta. Whatever's in the 1688 Bill of Rights, it is one of the main charters, and any of the clauses which are in it, which are reaffirmations of these, which the right to petition is, have to be upheld without breach. And we will, that the same charters shall be sent under our seal to our justices, both to those of the forest and the rest, and all the sheriffs, shires, and to all other officers, and that's the council as well, and all cities throughout the realm, together with our writs, in which it shall be contained that they cause the aforesaid. Now, charters to be published, and have it declared to the people that we have granted that they shall be observed. They shall be observed in all points, right? And that our justices, right, this is important now, that our justices, sheriffs, mayors, and other officials, that's the local council, and clerks of the court, which under us have to administer the laws of our land, and shall allow the said charters in pleas. So they've got to allow these charters. This is actually legislation now. This is legislation on the government modern website in legal effect. And this has not been claimed to have been repealed, right? This is actually of effect. That they shall be allowed in the pleas before them, in the judgment, and all their points. But it says before them, the pleas before them. That's in front of the court. Anything that is laid to the court, any case with the court that the court is hearing, right? But also the plea before when you are in session for pleas. This is the session for pleas. I'm in the session for pleas, right? But before the plea is entered, before them, this is in front of the justices, but before the plea is entered, right, before the actual plea, you recognise rights through overriding objectives which have to be recognised. You don't have to prove a right beyond reasonable doubt to a jury, because it is not a defence or part of a defence package, of which the prescribed rules are proved beyond reasonable doubt. Overriding objectives are recognised by the court. They're not proved to a jury as a plea, as part of a defence against a criminal charge. They're recognised by the court, right, before you enter the plea. But when you're summoned to respond, right, which is, I am claiming this right to be recognised, but I'm not pleading guilty or innocent because it's illegal to be prosecuted, right? So they have to be recognised by the courts, justices, and accepted. The points to wit, the Great Charter and the common law, and the Charter, and so forth. And here, this is the most important part, I suppose. And that if any judgment be given henceforth contrary to the points of the charters aforesaid by the justices, or by any other of our ministers that hold plea before them against the points of the charters, shall be undone and holden to none. So that means that why would a minister have a plea in front of him? You only plea if there's a civil case. You only plea if there's a criminal charge, right? Why would a minister be there? Or why would a minister be interested or looking at it when he doesn't have anything to do with criminal law? If you are petitioning either of Houses of Parliament or the King, it is the business of the ministers in the Petitions Committee or your local MP. And if you need the rights recognised which are being brought in respect of that cause through the right to petition, and Article 9 of the Bill of Rights, which is the exact same basis reaffirmed from the Magna Carta as set out in XIX chapter on public petitioning by Sir Thomas Erskine May, the Magna Carta and the 1688 Bill of Rights. You need your own court, your ministers to have your rights recognised from you. This is the basis of the Privileges Committee, the Committee of Privileges, the Petitions Committee. Right? That's the point. And it even says that if all this is not followed, or if all this is not complied with, then it is the requirement of the bishops to make sure that it is complied with. That is the Archbishop of Canterbury in the House of Lords, and or other bishops in the Protestant religion of the Christian church, right? To make sure that your rights are upheld, right? So there's a duty and obligation of ministers. Now, the Attorney General, who's meant to be the lawyer of Parliament, the Solicitor of Parliament, whose actually offices in the Ministry of Justice, but he's still the Solicitor of Parliament, right? If his job does not also include people's rights when they're petitioning Parliament, I don't know, whose does, even if it's the Privileges Committee that dispatches him. He is a member of the House of Lords, right? And the Lords is Parliament. And so is the Lady Chief Justice, who's in charge of the Judicial Conduct Investigation Office. And so is the Archbishop of Canterbury, a member of the House of Lords, right? And the Privy Council. If you have a right which has a legal obligation to be recognised, and if it isn't, then it is void and null, according to this, the order against you is void and null, then it is actually, according to the confirmation here, the confirmation of the charters, it's actually the bishops, the Archbishop of Canterbury, who are actually given in law. This is in force on the Parliament government website, right? The Archbishop of Canterbury has a legal requirement and obligation in the House of Lords to make sure that if your rights have not been applied by the courts, and if they're null and void in law, to make sure it is recognised and do something about it. Whether or not he tells the Attorney General to do it or the ministers directly, they've got, in the Constitutional Reform Act 2005, they've got Section 5, which is matters between Parliament and the courts. If you raise a rights claim in the court, and the right is to do with Parliament, then there's a procedure for that set out in the Constitutional Reform Act. Okay? There is a procedure set up for the courts, right, to write to Parliament and communicate about it, to have a right applied. Okay? And to get a resolution. A right to a resolution for it. You don't have to appeal to the High Court. Because if you've got a cause to Parliament, you already had a case with casework management, which was meant to be managed by Parliament, which is the Petitions Committee and Privileges Committee. And which basically means that if Parliament, if the Petitions Committee, I once complained to the Parliamentary and Health Service Ombudsman, which the Petitions Committee, how can I complain about the Petitions Committee? They said, we don't govern the Petitions Committee. There's no way you can complain to about the Petitions Committee to make them do anything other than writing to them. The Petitions Committee consists of individual MPs and a chair, right? You complain about the conduct of any individual MP to the Parliamentary and Health Service Ombudsman. So you're complaining about the MP's conduct and behaviour when they're in the Petitions Committee. But we're not even going to the Parliamentary and Health Service Ombudsman. You need your rights recognised and applied. And if there's an order against you which is null and void, it needs to be annulled and voided in writing on the court record. right? This act here says that in a situation, the ministers, the cabinet, have a legal obligation, particularly when it's petitions that are to the petitions committee, right? Not the local court, for the pleas, right? For the pleas. Well, there is no pleas unless you got a criminal freaking charge against you, right? So, and if this all isn't being done properly, you have to get the bishops to sort it out, which is the Archbishop of freaking Canterbury, right? So, where is this happening? You know, it's the petitions committee. Number 10, you know, the privileges committee. Judicial conduct is responsible for the conduct of justices. If a justice has contravened this, right, and not recognised your rights when you've got a legal right for them here to be recognised and applied and adhered by every point, that is a complaint against the judge, for sure. And this says that an order is null and void. Well, the judicial conduct say that they can't do anything about an order. That's not true, because, you know, there is situations where you don't have to appeal it. This doesn't say you have to appeal anything. It says if this certain thing is done, it hasn't been done. It is of no effect. Now, if there's a record by the court that is of effect, then it needs to be unaffecting. It needs recognising. Now, that is why we've got the Constitutional Reform Act, Section 5, at the moment. It is a use of it, among others, because the Petitions Committee are in Parliament, as are the Privileges Committee, right? As is the Archbishop of Canterbury. Although it says the House of Commons, but saying that, the Lady Chief Justice herself, in her capacity as the Lady Chief Justice herself, right, which there's loads of arguments over the JCOI being under Freedom of Information Act or not, which they're saying it is. But the Lady Chief Justice, with her communications to Parliament, Parliament's got its own, separate freedom of information and so forth. But the Lady Chief Justice is a member of the Privy Council of the King and the Archbishop of Canterbury, and also of the House of Lords, although she doesn't vote in the Lords, but she's got to perform functions of the House of Lords other than voting, part of the judiciary. She fulfills... She's there to represent judicial actions, right? So the Archbishop of Canterbury has a personal responsibility for these charters being upheld and put into effect, because he is like the spiritual enforcer when people's consciences within the government are not just, when they're not complying. What is a spiritual leader for? For truth, honesty, sins, so forth. Which means that the Archbishop of Canterbury has to, it's like confessions, isn't it? He's got a judicial function. Well, this gives him a judicial function. The Archbishop of Canterbury has got a judicial function through this act of, sorting out the conduct and behaviour of Parliament when it comes to rights claims. And that's in it's also at the start of the 1688 Bill of Rights. The 1688 Bill of Rights says that evil ministers, justices and councillors, right, if they're subverting the rights and liberties of the realm, right? So the Archbishop of Canterbury is responsible as a holy figure in Christian law, entrenched in English law, in the procedure of the courts, in criminal proceedings, on swearing on the Bible that you will tell the truth, the whole truth, and nothing but the truth, so help you God. If a justice is not complying with these charters, when it's a legal requirement, so help him God, the Archbishop of Canterbury will make him tell the truth, the whole truth, and nothing but the truth about your rights. When he's subverting the liberties of the realm, so help him fucking God. Is his legal requirement and function as the Archbishop of Canterbury to enforce the rights and liberties of the realm of England in the courts of fucking England, when you are legitimately claiming a right under those charters. It says in here it cannot be repealed or altered in law, in English law. And that is what it says in here.